Good morning. I'm Jane Fielding and I'm head of the Employment, Labour and Equalities team here at Gowling WLG in the UK. And I'm delighted to welcome you to this, the second webinar in our series of annual update webinars, when we take a look at what we think you need to know as HR professionals and in-house lawyers as we head into 2023. Our topic today is data protection. I think when the Data Protection Act and then the GDPR came into force, probably those of us in practice were few and far between who thought this would really take off to the extent it has, that it's become such a feature of our daily working lives. Whether it's a grievance, every second one seems to have a data subject access request attached to it, whether it's a transaction involving TUPE and the outgoing employers refusing to provide the employee information because of data protection. It's a daily feature of our lives these days, and therefore it's really important that you understand what to do and what not to do. I think we had a brief hiatus in the data subject access requests in the pandemic when everybody was sadly otherwise occupied, but now we are certainly seeing them coming back. So we thought it was a good time for a refresher on this. So our speaker today is Karin Kehoe, one of the senior associates in the team. Karin has a broad practice ranging through employee relations, litigation in the tribunals and transactional work. So she's very well placed to help you with the sort of day-to-day queries that come up and give you some tips to make sure that you're handling this in a compliant way. So Karin is going to speak for 30 minutes or so. We will leave some time at the end for questions. If you want to ask a question, please can you use the Q&A function rather than the chat function. So the Q&A function, probably everybody knows where it is since we've all been using Zoom for so long, but just in case, I will say it's at the bottom of your screen in the middle. If you could ask the question with your name, I'm not going to name you on the webinar, it's just that if we don't get to your question, we want to be able to follow up with you afterwards. And if you ask it anonymously, obviously that's a bit tricky. If you have a tech problem, hopefully you won't, but again, if you do, then please use the Q&A function as well. And Lucy Strong, who's helping us behind the scenes with the tech, will do her best to sort that out for you. And it's my job to make sure that I field the questions, but also that we finish promptly at 11:45. So I commit to do that. Excuse me, we will be sending a short email questionnaire around afterwards. It only takes a couple of minutes to fill in, and we really would appreciate it if you would do that so that we can use your thoughts and comments to shape future sessions. So I will now turn my camera off, go mute, and hand over to Karin.
Thank you, Jane, and good morning, everyone. And I'd just like to say thank you for joining us. So as Jane mentioned, I'm going to be talking today about data protection and specifically monitoring staff at work. And the particular focus of the webinar will be on the ICO's latest draft guidance on monitoring staff at work. So in terms of an agenda, I'll be covering off what monitoring actually means and why an employer might want to do it. I'll then briefly cover off the law and what we've currently got from the ICO. And I'll then address what's different in the latest guidance that they issued back in October. And I'll then end the webinar with some practical tips to help improve compliance in your organization. Now, I should add a disclaimer, as you probably expect, that data protection law is incredibly complex and very involved. So within the time I've got available, especially, it would be possible for me to give you an all-encompassing overview of everything you need to know. So it's very much intended to be a whistle-stop tour with an employment focus. So what do we mean when we talk about monitoring staff at work? I mean, really, it's a form of surveillance, and its purpose is to obtain information about staff activities in the workplace. And obviously, electronic monitoring will now be the most common form of monitoring, I would expect, in the workplace. And you could have something like CCTV cameras, and that would be the most overt form of monitoring. You could be monitoring through other means, so looking at emails or email traffic. So, for example, volume of emails going in, coming out. You could be looking at phone calls or monitoring through phone calls. So something like the volume and cost of phone calls, or you could be recording the content and monitoring the content. And you could see that happening maybe in a call center context. You could be monitoring through the internet. So, for example, you could be blocking off certain inappropriate websites for employees or social media websites. And you might have systems in place to alert you if anybody tries to access them during working hours. And you could be monitoring through other devices. So I've come across printing systems, for example, that tell me how many trees I've effectively killed with all of my printing. And while it's a bit disheartening for a junior working on tribunal bundles, it's certainly something that might be beneficial in some circumstances. So why would an employer want to monitor their staff? I mean, there could be a whole host of reasons. An obvious one might be to protect your interests. So, for example, the use of confidential information. And in the course of preparing for this webinar, I actually came across a report that said that around 24% of UK employees had intentionally leaked confidential business information to third parties. You can definitely see why that might be an important reason to monitor. And certainly you can see it happening if, for example, you've just given notice or you've just dismissed an employee, and they then log onto their laptops to see what confidential information they can take with them. Now, if you have certain systems in place, or sufficient systems in place rather, to alert you when they try to access your confidential information, then if you can't prevent the access, then at the very least, you might be able to do some damage control afterwards. You could alternatively be monitoring for performance or quality of service purposes. So going back to the call center context, if you get a customer complaint, you might go back to the recording of your phone call or the customer service advisor's phone call and see what, if anything, went wrong. You could be monitoring to identify certain conduct or conduct issues. So if you get an allegation of cyberbullying from one employee against a colleague, then you could be looking at the colleague's use of internet and whether they've logged onto social media sites, for example, to perhaps send inappropriate tweets or whatever else messages. And that could be a helpful tool for investigatory purposes. You could be monitoring for health and safety, so making sure that your staff are complying with health and safety policies, and that could be particularly important in, say, a warehouse or factory setting. There could be regulatory reasons for monitoring. So some financial services firms are actually required to record certain phone calls, and that's at the request of the FCA and the regulatory framework. And the reality is that there could be a whole host of different reasons. For example, you might even be looking to prevent potential reputational issues that may arise from data breaches. And actually, some years ago, there was an agreed employee of a supermarket that ended up uploading payroll information online. Now, that in itself attracted media interest, and it was widely reported at the time. But it actually also led to litigation, which lasted a number of years. So you can certainly see where reputational issues could come into play, particularly where there's a risk of media interest. Now, you might say to me, we've been monitoring for years. I mean, what's the big deal? Why are we so worried about this? Well, you might not necessarily be worried, but certainly when you're talking about monitoring staff, what you're really talking about is processing personal data. And that's when you get the GDPR and the Data Protection Act involved. And while those have been around for a number of years, and the majority of organizations will have already taken steps to ensure compliance, the ICO still has powers to issue significant fines for non-compliance. And it can go up to £17.5 million or 4% of total global annual turnover, whichever is higher. And the ICO is certainly not afraid to use their powers, because I was trying to look up what the higher fines have been in recent years to illustrate the point. And I saw that an airline had been fined about £20 million and a hotel group was fined over £18 million. So the fines can be very high. And data protection issues aside, there could actually be a whole host of other legal considerations that you might need to bear in mind when it comes to monitoring staff. So public sector organisations, for example, might have to think about the right to privacy at work under the European Convention of Human Rights. All employers might have to think about whether their monitoring could breach the implied term of trust and confidence. And if it does, could that lead to constructive unfair dismissal claims? I mean, in most circumstances, I wouldn't expect normal type of monitoring to be breaching that implied term, but certainly if it's going to be particularly intrusive or covert, then there might be a risk of that. There might also be other considerations, perhaps more criminal in nature, when you talk about unlawful interception of electronic communications. So there's a whole host of things to think about when you start monitoring staff or want to monitor staff. So what does the law actually say insofar as data protection is concerned? Well, monitoring isn't actually prohibited, but it's also not expressly permitted. And the bottom line is that it has to be carried out in compliance with data protection principles. So you very much need to be looking at things like purpose. You know, why are you collecting or processing the data? Why are you doing the monitoring? You need to have a legitimate purpose that is specific and lawful. And you shouldn't be relying on all of the lawful bases that you could possibly rely on, because you need to be specific. So taking the strategy of drafting a very wide privacy notice, for example, in case something bites in the future, isn't going to be sufficient. In terms of scope, you would need to think about making sure that your monitoring is proportionate to the purpose that you've identified. So this is all about making sure that the processing is adequate, relevant, and necessary for the purpose you've identified, and you effectively aren't going any further than you need to. There's also the fairness and transparency principles, which are fairly fundamental to the data protection framework. And this is very much about telling your employees of the monitoring activities you're carrying out. And that would usually take the form of a privacy notice. And actually, we have had cases before where an employee has challenged the use of a CCTV recording in a disciplinary context because the privacy notice hadn't said that it could be used for that purpose. So that could add a layer of complication. And you need to think about things like security. So making sure you've got the appropriate technical and organizational measures in place to prevent data loss or unlawful processing. And again, this is another area where things can go wrong, particularly as around 88% of all data breaches arise from human error. So no employer is going to be 100% immune to this. And actually, a relatively recent example is when the ICO fined a construction company because their systems didn't prevent a cyber attack. And in that case, an employee received a phishing email. So that's an email that looks legitimate, but actually isn't. And they forwarded it to a colleague. The colleague then downloaded the content, and that ended up installing malware onto their workstation. And it ended up compromising the personal data of over 100,000 individuals. And they actually ended up getting fined over £4 million. So it got quite significant quite quickly. And when you're thinking about monitoring in particular, you have to bear in mind potential other considerations. So things like special category data. So if you're going to be processing special category data, say trade union memberships or ethnicity, then in addition to complying with the usual principles of data protection, you need to identify an additional exceptional ground for processing that data. And equally, if your processing is going to result in a higher risk to personal data or may result in that risk, then you'd need to carry out a data protection impact assessment. So that could be, for example, if you're going to be using biometric data to control access to devices or a building where you might work. So with all that said, what have we currently got from the ICO? Well, we currently have an employment practices code, And monitoring at work does feature in the code. It's in part 3 and it's around 19 pages. And I'm sure it's been light bedtime reading for many of us. And it broadly covers the items I've listed on the slide. So it provides an overview of monitoring, and then it provides the specific considerations for the various types of monitoring that are listed in points 2 to 6. Now you might ask, if we've got the code and we've got an existing document that we're working with, why is the ICO changing it? What's prompted all of this? Well, the bottom line is that the code is very much out of date. From what I can see, it hasn't been updated since about November 2011. And we've obviously since had the introduction of the Data Protection Act and the GDPR. We've also had Brexit, which has made us a third country for the purposes of data transferring from the EU. So that again hasn't been reflected. Obviously, over the past 11, 12 years, we've also had significant improvements in technology and the way in which we use technology in the workplace. And again, that's not reflected. And actually, the ICO produced a call for view summary report following its initial consultation. And it said that respondents were very much concerned about technological advancements and sophistication of monitoring tools nowadays. And while the ICO said that the same data protection principles would apply, so it's no different if it's old technology or new technology, it would be updating its guidance in due course. And we've obviously had the COVID pandemic, and I'm sure we're all sick and tired of hearing about it, but it's certainly impacted on how we work, or I guess more precisely where we work, because there's been a huge trend towards hybrid or home working. And that obviously can affect monitoring activities which haven't been properly reflected, but I will talk about that in a bit. And again, unsurprisingly, that was a key theme that the ICO identified in the summary report that it produced. So in terms of what the ICO is actually doing more widely, I mean, they are doing a wider overhaul, but they're not looking to replace the code with a new code. What they're looking to achieve is effectively to create a web-based hub of guidance. So what we can expect from that is lots and lots of updates to the ICO's website in the future. So let's then look at what is in the new guidance document on monitoring. So what we got was a document called Employment Practices Monitoring at Work Draft Guidance. And as the slide says, it was published on the 12th of October, 2022. It is aimed at all organizations, both public and private, so that's helpful. And its purpose is said to be to provide clear and practical guidance on monitoring workers in accordance with data protection laws and to promote good practice. And this is actually very similar to the purpose set out in the current code. But obviously the ICO has adopted a different strategy in how they want to achieve it. And in terms of where we are with the draft document, the consultation on it ended last week on the 20th of January. So at the moment, it's very much a case of watch this space. And I think I would in the meantime highlight that because this is only a draft document, there's not yet a need to do anything necessarily within your organization on the back of it. So worth keeping an eye out for when the final version is published and then looking at what, if anything, needs to change internally. So what does the new guidance actually contain? So the starting point is that it's about 54 pages long. So clearly compared to the 19-pager in the code, it's a lot more detailed and very focused on monitoring, which is in many ways helpful. And it covers the 5 points that I've listed on the slide. So very broadly, how to lawfully monitor workers, so an overview of the law, talks about automated processes, provides a checklist of lawfully monitoring workers. And the bulk of the guidance is actually on point number 4, specific considerations for different types of workplace monitoring. And then lastly, it ends with how to use biometric data for time and attendance control, as well as monitoring. And I'm going to take you through each of these sections in turn. So the first section of the draft guidance is lawfully monitoring workers, so effectively an overview of the legal position. And now, since I have already summarized some of the key principles earlier in the webinar, I'm not going to be covering that off again. I'm sure there's a sigh of relief. But what I have focused on in this section is how the guidance document compares to the code. So my impression is that the guidance document is quite practical, as it provides a simple overview of the legal framework. And it very much breaks down the data protection principles with easy to digest examples to bring it to life a little bit more. What I also quite like is that the draft guidance signposts you to the relevant pages of the ICO website. So if there's something that you might want to bear in mind, but it's very detailed and complicated, then instead of sending you down a rabbit hole in the same document, it just tells you where to look on the ICO website. And there's also other considerations that I thought might be worth flagging on this webinar. From my impression is that there's a bit of a shift in some of the emphasis that the guide has compared to the code. So the change in emphasis has been, for example, in relation to data protection impact assessments. While it is covered off by the existing code as well, there seems to be a greater shift in the draft to actively promote completing one as a matter of good practice, even if there's no high risk to personal data from your monitoring or processing. And that's partly to evidence compliance. Equally, there's a greater focus on consultation with employees in the latest draft, but that's particularly if you're introducing a new form of monitoring. And the guidance document goes into quite a lot of detail as to why it's beneficial to consult. It's really to improve transparency, build trust with your workforce, and minimize complaints if you take feedback early on any concerns that your employees may have. And the draft is also very strong in its emphasis on the need to record any consultation that you do undertake. And if you choose not to consult, you would need to have a good reason for it. And again, you need to record that decision with a clear explanation. So there's very much a theme, in my view, of keeping records to evidence compliance. And it might give us a bit of a clue as to what the ICO might be expecting in the event of a data breach, to see lots of records and documents effectively evidencing compliance. So the next section is all about automated decision making. So this is effectively a form of making decisions about your workers and employees without any human involvement. And in the workplace context, you could see that happening, for example, in absence management. Now, it may not be relevant to all organizations, but certainly relevant to those organizations that do use automated decision making, because it carries potential risk if it's not used carefully. And the draft guidance highlights that the risk is that there could be inaccuracies and there could be potential for discrimination. And again, if we take the example of absence management, so even though an automated decision might be to progress an employee who's absent to the next stage because they've hit a certain level of absence, there is a risk that actually they might be absent because of a disability, in which case, is it the right thing to do to jump to the next stage of the absence management process without first considering something like reasonable adjustments? And if you fail to take reasonable adjustments into account, there could be a risk of a discrimination claim. So bearing in mind the extra risk that exists with automated decision making, there are additional restrictions in place to any sort of decision making that doesn't involve humans. And this includes having a narrower scope, a narrower set of purposes on which you can rely for automated decision making. There's also a big emphasis again on telling your workers, and you should be telling them not only about the significance and consequences of processing, but also the logic involved behind it. There's also other considerations to bear in mind. So the need to introduce simple ways to request human intervention, and also making sure you're carrying out regular checks that the systems aren't going completely rogue and that they're working as normal. And insofar as human oversight is concerned, the key emphasis in the guidance is to make sure that any human intervention is meaningful. So it needs to be critical and challenge the outputs of the system. So when the computer says no, not necessarily accepting that it says no. And if it's being used as a decision-making support tool, then the system recommendations again need to be checked, and you need to bear in mind wider factors. So take the example of absence management. What is the reason for the absence? That's unlikely to be something that the system itself takes into account, so the human would need to do it for it. The next part of the draft guidance is to set out a checklist, an easy checklist to basically ensure compliance with the legal principles when you're monitoring staff. And the reality is that the ICO has been using these types of checklists for years, so it's not necessarily new. And it's understandable why they're continuing to use it, because it will help focus minds. It will also encourage and simplify compliance. And even though I haven't come across it in practice, it is possible that if you do complete checklists as a matter of course for monitoring staff, then it may be good evidence of compliance or attempted compliance in the event of a data breach. We then get to the next section of the guidance document, which sets out specific considerations for various types of monitoring. I've listed the various types that the guidance covers on the slide, but I'm not going to take you through each one in the interest of time. But I have selected a couple which I think might be interesting to flag. So this is all about audio monitoring and recording face-to-face conversations rather than just monitoring business calls. And what the guidance says, rather unsurprisingly, I think, is that this type of monitoring is highly intrusive and it's unlikely to be justifiable in most circumstances. It actually even goes on to say that continuous audio recording is more privacy intrusive than purely visual recording via CCTV camera. So it needs to have an even more robust justification. The draft recommends that the default position should be to switch off any capability to audio record. And that's to limit the scope of the processing and the monitoring you're doing. And it should only be used in exceptional circumstances and switched back on in exceptional circumstances. So, for instance, you might have audio recording capabilities in your office, but they're switched off by default. But if you need to carry out a specific investigation, say into unlawful activity or alleged unlawful activity, then you can switch it on for that purpose alone. So the audio monitoring very much needs to be particularly targeted at a specific risk. And it should also be confined to areas where there's no or low expectation of privacy. So if you take the example of a conference room versus changing rooms or bathrooms, there's obviously going to be a much greater sense of privacy in a bathroom or a changing room than there is in a conference room. And if you are going to use audio monitoring, in addition to complying with the usual principles, the draft guidance recommends that you complete a data protection impact assessment to effectively set out the pros and cons of the monitoring that you're doing, as well as explaining why the monitoring is necessary in the first place. Again, and unsurprisingly, there's an emphasis to tell your workers about the extent and nature of monitoring and why it's being carried out. And there's also an emphasis on making sure that anyone caught by the monitoring, so anyone visiting the office, for example, is aware of the monitoring and its purpose. And another thing that the guidance document emphasizes or flags for you to think about is if you do get a subject access request and the audio recording falls within the request, how will you be redacting the personal data of third parties? It leaves you with a nugget to think about. Another area that the draft guidance covers off relates to monitoring home workers. And obviously the draft recognises that there's been an increase in remote and home working, but actually it's really light on the guidance as to what to do about it. All it says is that it acknowledges there's a greater expectation of privacy at home, so there is obviously a greater risk of capturing family and private life. But other than to say, factor this into your planning, it doesn't really provide much more assistance. And that's actually interesting because the Call for V's summary report that I referred to earlier said that monitoring home workers was actually one of the most frequently recurring themes amongst respondents. And it also emphasized that it is a key priority area for the ICO. So what I suspect is that we might be getting more specific guidance on it in due course. And whether it's in this sort of a guidance document or on the website is yet to be seen. And the last section of the draft guidance is all about biometric data. So unhelpfully, it sets out the GDPR definition of biometric data, which I don't think is particularly user-friendly. But in layman's terms, it's effectively information related to people's characteristics that's used for identification purposes. And it includes things like fingerprints and facial recognition. And although it sounds fairly sci-fi, the reality is that these systems are being used very frequently now in the workplace. So you could have things like laptop access governed by fingerprints or facial recognition. And the guidance is actually quite detailed on biometric data and using biometric data to monitor workers. I'm not going to cover all of it, but I have suggested picking out a few of the more interesting points to flag. So the guidance document does say that biometric data could be special category data if it's processed to identify a specific individual. And this means that it would need an additional condition for processing in addition to complying with the usual data protection principles. And actually what it says is that consent is likely to be the most used additional condition for processing biometric data. And to ensure it's validly given, you should offer an alternative option to workers so that they can make their own choice as to whether or not they want their biometric data to be used. But the key is there to make sure that the alternative option that you give to non-consenting workers isn't going to be any less advantageous. Another big issue that the guidance document flags with biometric data is the statistical accuracy of the system and the fact that it might not be 100% accurate. So the guidance document very much says that it's your responsibility as the organization using it to make sure that the match rate and the risk of false negatives are made clear. And that's even if the system is being provided by another organization. And it also says that you need to have in place an easy alternative if things go wrong. So if there's a misreading of biometric data, the option to manually override any false readings. Another concern with biometric data could be that there's a scope for discrimination. So some studies apparently have shown that facial recognition is less precise for some demographic groups. And again, the guidance document says to make sure that the system is suitable for the groups and individuals that you're planning to use it for. So with that all said, has anything really changed? I think the reality is that there's been no earth-shattering revelation. The guidance document is very much about being up to date on the law and the relevant current working practices. My view on the whole is that it is easier to follow because it breaks down the law in simpler terms with good examples, but it does already add length if you already know the legal position and just need the practical checklists. And obviously some sections, such as monitoring home workers, will need some more work. So whether or not it's going to be included in the guidance or on the website is to be seen. And I thought I'd end the webinar on some practical tips. So when it comes to data protection, no one size fits all approach is going to be suitable. It's very much a matter of taking stock of the data you collect and making sure you're doing it in compliance with data protection principles. When it comes to monitoring, a key point is to inform your staff, to make sure they know what data you're collecting and why as part of your monitoring. So this is all about making sure that your privacy policy is sufficiently widely drafted, but also being quite specific again on the lawful basis on which you're doing that, the monitoring. You should also be considering whether to consult with employees to try and improve workplace relations, improve trust, and try to minimize the risk of any complaints. A key emphasis, a key theme in the draft guidance document is about keeping records, making sure that you have appropriate records of what you've done to comply with data protection considerations. So if you decide not to consult with your employees, what's your reason for it? Is it good enough? Have you recorded it? So also, you might also want to think about training, because if a huge amount of data breaches are down to human error, then you might need to provide some refresher training. And I'd certainly also recommend keeping records of it, because I think most of us have come across a disciplinary hearing for a breach of a policy that the employee claims they've never seen before in their lives. So it's very much worth keeping records of what training you provided, to whom and when. And if there's any way of receiving confirmation from employees that they've read a certain policy, or maybe they've completed a test to check their understanding, then that can obviously be helpful as well. Given that the ICO is overhauling their website and their guidance documents, it's very much worth keeping an eye out for any more updates, and obviously seeking legal advice if that is needed for any particular issues it may have. So I'll now hand back to Jane.
Thanks, Karen. So we've got quite a few questions. The first one was about something that you touched on towards the end, as use of biometric data. So you talked about the fact that to make sure any consent to use that was a valid consent, which obviously is quite difficult in the employment sphere under the Data Protection Act. It was important to give an alternative that didn't disadvantage people, so that the request is for an example of what that alternative might look like.
Okay, so you could take the example of say work laptops that use facial recognition for access. Now, you'd obviously offer employees the option of signing up to access their laptops with facial recognition, and that's if they consent to the use of their biometric data. But for those that don't consent, the key is to provide an easy alternative option to make sure that they can still access their laptops, but it doesn't mean that they have to, go through extra hoops to do it. So instead of making all non-consenting employees spend, 30 minutes in a queue to the IT team to try and remotely get access, you could offer the obvious option of, a simple PIN code or a password. So it's very much about making sure that the alternative option doesn't disadvantage them, isn't more time consuming, and is as simple to use as the facial recognition option.
Okay, so the next question is a scenario that I'm sure many people on the webinar will have come across. So they've got an employee who's threatening to report them to the ICO for a data breach. And the question is there anything specific that they should be doing having received that threat?
Well, I think it very much is a case of it depends on the circumstances. It's the famous line that all of us lawyers tend to provide in the first instance.
Often the best advice.
Yeah, and you may want to take specific legal advice on it, because obviously it can be quite complicated. But I guess from an employee relations point of view, the first thing you might want to do is just acknowledge, the fact that they've flagged this concern and say that you'll look into it. And in terms of what you do with the threat itself, I mean, you can't prevent, or you shouldn't be trying to prevent, a complaint to the ICO, but instead you might want to look at what's actually prompted them to make it. Is there a potential legitimate data breach that they're referring to? And if there is, you should investigate it, make sure you understand why it happened, how it happened, what data is affected, and what you can do about it to try and limit the damage. And also what you can do to prevent it from happening in the future. And another thing, I guess, to think about is that there are reporting obligations if the data breach could lead to risk of harm. So you'd not only need to report it to the ICO in a relatively short period, I think it's 72 hours from when you've found out about the breach, but you may also need to tell the data subjects, so potentially the employees whose data has been compromised. So really this requires some sort of an assessment of, is the data breach very serious, or is it just a minor mix-up where not much has happened and there's not really going to be much harm to it? And I guess strategy-wise, it would be worth thinking about whether you want to write to the ICO regardless. So whether or not you've got enough information to know if a report's been made, you might want to act preemptively, send them a letter to say, this is what's happened, this is what we've done to control it, this is what we've done to make sure that it doesn't happen again in the future. And while it may not prevent the ICO looking at it quite carefully and investigating, at least it might help show them that actually it's a concern that's being taken very seriously. It's not being ignored, and steps have been taken to try and minimize the risk of it happening in the future. And that may disincentivize the ICO from focusing on it maybe as much as it may have otherwise done.
So sort of get on top of the facts and don't be defensive, I suppose. Yeah. Okay.
Basically, yes.
So there's a couple of questions on the next topic, which we'll try and squeeze in before we have to finish. It's a lot of what you talked about was about employers monitoring data of employees, but a couple of people have asked the question, well, what about the other way around? And it's a scenario we see, I would say, increasingly, where an employee makes a covert recording, perhaps of a disciplinary meeting or something, where trust may already be low. Isn't that already a data breach, is the question, and what can you do about that?
Well, I mean, as you say, Jane, it is a hugely contentious issue, and I actually do come across that quite a lot. I think we all do when we're advising on disciplinary hearings or something along those lines, or in the context of, I guess, litigation. I mean, in theory, it's possible that there could be a data breach by the employee if they covertly record a meeting without consent or without having agreed it. I guess there could equally be an argument that it might fall in the sort of household exemption because it's a one-off and it's an individual doing the recording. So there might be an argument to say that actually the data protection legislative framework doesn't actually capture that type of recording. And I guess in terms of what you can do about it, it may be a disciplinary issue. So it could be a form of misconduct, if not gross misconduct, although probably not gross misconduct in most circumstances, but obviously it depends on the facts. It could be a breach of confidentiality, and there's an argument to say that it might undermine the implied term of trust and confidence. So it could go back to the gross misconduct point, but that might especially be if an employee has been told not to make any recordings. But I guess in reality, we don't often see employers acting on, taking very serious action against employees who do covertly record, because usually there's nothing really to hide anyway.
Yeah.
I guess Oh, sorry, I was just going to add one more point around litigation, because it's a question I get very often. About recordings, I often get the question of whether they can be admissible, whether they can be used in court proceedings. And the short answer is that they might be able to use it in court proceedings. But it doesn't look very favorably on the person who created the recording. So it might go to the character, to the question of their character more generally.
Yeah. Okay. Thanks, Corinne. So we've hit 11:45, so I'm going to draw it to a close there. I'm sorry we didn't get to all your questions, but as promised, we will come back to you afterwards if you're one of the people who we weren't able to answer the question for. Please do fill in the questionnaire when you receive it. It will only take a couple of minutes. And I hope that you can join us next Tuesday for our third webinar, where I'm going to be talking about philosophical belief protection, and with a particular focus on the current debate around gender identity and gender critical beliefs. So I will just say thank you very much to Corinne, thank you to Lucy, and thank you to all of you for joining us. And I hope you have a good rest of the day. Goodbye.